Welcome everyone to this session, which we do intend to be as kind of genuinely collaborative as it can be. So if there's a point that you would like to raise or explore along the way, please just raise your hand and we will do that. We're both members of Chambers, Lucy and Anson, and we're going to talk to you this morning about professionals and economic crime. I chose on slide 1 a painting from 1857 called The Bribe, and it hangs in the Royal Academy. And this unnamed individual has just bribed the jailer for access to the prisoner, who we can assume is on the other side of that door. And I chose it just as a kind of momentary visual aid to what we're exploring this morning, a kind of fascinating and shared world where the two worlds of civil and criminal liability are enmeshed, and where inevitably, if we are advising in this context, it means something may either go severely wrong or has already gone severely wrong, which is of course part of what feeds the fascination. I was going to start with a couple of preliminary points to explore. First of all, the perspective of the professional and what do we mean? And what are the circumstances in which we as professionals and as advisors may need to have an understanding of some of these concepts? And an idea of the range of civil claims and issues which might arise around them. First of all, in-house counsel. And we're going to explore the sort of principles that underpin the failure to prevent offences. And of course, immediately in that context, it is all about compliance. And Anson is going to introduce those concepts during our session. But in-house counsel with significant, huge responsibility in the context of setting up prevention procedures, which will prove invaluable by way of defence should allegations be made. Anyone else who is going to be advising the in-house teams in that context, and the circumstances in which one might find oneself advising in-house counsel teams and the company itself. That might be in a compliance context, how to avoid the kinds of problems that can arise. It might be at an investigative stage, including what advice they now require and the capacity in which they require, critically the capacity in which they might require that advice. We might be advising directors whether or not there's a suggestion of personal criminal liability on their parts or some other form of liability. And of course, and this is an issue I'm particularly interested in at the moment, circumstances in which one might be advising advisors, legal advisors, who have at some point advised the company or directors in respect of an acquisition, a course of action, a risk profile, for example, of an intermediary or a new client, of what they intended to do or not do, and whether or not that might ultimately prove to be a breach of one of the relevant statutes. Lastly, I suppose the regulatory implications, so the locking together of compliance and regulatory issues in this context, including in the context of FCA-regulated entities. And one thing to be, I think, immediately aware in this context is the degree of collaboration between the criminal and the regulatory agencies. So, for example, between the FCA and the National Crime Agency, and the number now of joint publications, either as guidance or as really statements of intent. So they published together 9 economic crime priorities for the regulated sector back in the summer. So a real alignment of public and private sector efforts in that context. So one can immediately see, just against that backdrop, the range of kind of acute issues that could arise for us advising our clients. And I've set those out now in the hope they kind of play into our discussion a little later. By way of a sort of second preliminary point, the parameters of many of the concepts we're talking about are essentially untested in the English courtroom. Where they have been tested, in often acute contexts, it's frequently confidentially and secretly, and it doesn't see the light of a courtroom. And I find this particularly interesting. And one of the reasons for that is the, I think, willingness thus far shown of the SFO and other organisations to negotiate with corporates, to enter into settlements and arrangements with corporates, including deferred prosecution agreements, if those corporates are capable of showing a certain degree of engagement and cooperation. So there's a kind of small degree of irony maybe in the fact that there is a kind of lack of transparency around some of these issues. So if you can just ping to slide 2. Thanks, Anson. So we'll start with failure to prevent bribery, Section 7 of the Bribery Act 2010. And this was the first of the failures to prevent offences to come into statute. And one of the 4 key offences established by the Bribery Act 2010. And the offence is the failure by commercial organisations to prevent bribery committed by their associated persons to obtain or retain business or an advantage in the course of business. So to take an example, there was a report in spring 2025 that the SFO has charged a UK-based insurance broker for failing to prevent its overseas agents from bribing Ecuadorian public officials. The bribes were allegedly paid by US-based intermediaries retained by the insurance broker and paid to state officials in Ecuador about 10 years ago to secure contracts. So to give an idea of the scale, probably bribes of a few million is what's being alleged, as against contracts worth 10 times that much. And so far as I can't find much out about it, but it sounds as though it may come to trial in mid-27. Whether it does or not is another question. But from that example alone, one can immediately see how the challenges of this kind of case might be enmeshed with issues that we are all regularly concerned with. And that one, just to kind of begin to imagine what might be happening there, or in a similar context, what additional controls would one need when doing business in a red flag jurisdiction like Ecuador? So if the risk profile is objectively elevated against the perceptions index or anything else, what extra steps need to be taken? And how far is a company who is doing any business in that context already on notice of risk of bribery? How does that work in terms of the compliance model? And how does that work in terms of the compliance model if that is an unusual transaction for the company? The risk is obviously immediately elevated, but what can one be expected to do about that? How does that fit with regulation? And it has been, I think, quite an interesting moment for UK investigations and the UK leading some of these investigations because of the pause in the US of investigations under the Foreign Corrupt Practices Act, which is an act I'm going to talk about a little bit later. And contractual issues too in this context, contracts with intermediaries. It's all very well having an express requirement that they don't bribe people, but what else might you need? Might you need rights of audit? Might you need termination rights that are more sensitive to red flags than one might ordinarily expect? And what transparency can you realistically expect, let alone insist on, between a brokerage and a foreign intermediary? But of course, I think this is one of the most interesting aspects of the topic. The extraterritorial reach has immediate implications. What do you as a company need to know about your intermediaries? What do your advisors need to advise you to find out about your intermediaries? What degree of due diligence will be expected? And most of these issues from an economic crime context has not yet been tested or explored in courtroom resolutions. To give another example, the deferred prosecution agreement entered into in December 2023 by the CPS with Entain PLC, which is a sports betting business. That was a £615 million deferred prosecution agreement in respect of bribery offences occurring primarily in Turkey, the first ever CPS DPA. No publication of the statement of facts or the full judgments, because there is an associated prosecution now of individual directors with bribery offences, and I'm involved in some of the associated civil claims. But that's a particularly interesting case because there's another public domain associated civil claim. Entain is facing a class action by shareholders alleging that Entain failed to report its knowledge of bribery and corruption and failing to have correct procedures in place, with the result that led to a drop in share value. So one can see all kinds of misrepresentation claims which might spiral off from allegations of corporate criminal activities. And I said also I was just going to briefly mention the FCPA-related proceedings. So in the US, and a really interesting example from my recent experience is the Varley and Steinmetz litigation, which was in the commercial court in 2022. Now, that was just one facet of litigation which kind of span around the world relating to bribes made or allegedly made in French Guinea in respect of the acquisition of some mining rights. And Vale sought in the commercial court proceedings to prove civil wrongs, fraudulent misrepresentation in particular, against a range of individuals, including our client, Mr. Steinmetz. Really interestingly, they got into difficulty on limitation because of the US-based investigations under the FCPA were partly in the public domain, and they were partly available on a public sort of US docketing system in respect of prosecutions going on in New York. And so we were able to allege that they had knowledge of certain things that had happened because they were already being investigated and in fact reported upon in the US. So the fact of criminal prosecutions can be really highly relevant to civil time bars. The other quite interesting kind of intersection that we had there is that we made allegations of illegality against Vale by way of defence, and those were actually based on the FCPA, the Foreign Corrupt Practices Act. And those were based on anti-bribery provisions. So we were alleging that the relevant illegality was their knowledge that the defendants were going to use funds for a prohibited purpose. And that's quite interesting in the context of the sort of offences we're talking about this morning. Could they, under certain circumstances, be sort of transmuted into illegality defences in a civil context? So I've covered quite a lot there, but deliberately trying to bring in some of the cases that have at least touched on these issues so far. And Anson's going to take us into the next section.
So Lucy's covered the Section 7 of the Bribery Act. There is however, defence that you can have for this particular offence, which is that if an organisation can prove it has had adequate procedures in place to prevent the persons associated with it from bribing, then they will have a defence to that offence. But then obviously the question is, what exactly is an adequate procedure? So the Ministry of Justice has this January this year given quite helpful guidance on how they are going to assess whether a procedure is reasonable. And it's by reference to the 6 principles that you see on the slides there. And if I can just take the first 2 principles, proportionality and top-level commitment, and just talk through how that works. Because the guidance makes it very clear that what is a reasonable or adequate procedure is very fact-dependent. It's dependent on your company, what it does, what sector it's in, the size of the company, which markets you operate in. So this obviously goes to proportionality because you have to first ask yourself, what bribery risks do I actually face when I'm in the operation of my business? If you're a small or medium-sized business in the UK operating here, you might comparatively face minimal bribery risks, for example, as compared to a large commodities trader like Glencore. So, which obviously we know that at the moment there's big commercial litigation about Glencore precisely for those issues. So the factors in assessing that risk include, the particular country you're in. Do they have quite a lot of high level of corruption there? The sector, for example, commodities is a prime example of one in which you might expect there to be more bribery risk. The value and duration of your project and the kind of business you want to do, and the people you engage for your business, for example, if there are intermediaries in the between who will expect some sort of kickback. So how do you assess those risks? Again, it's simple practical steps such as internet searches about the level of corruption in a certain country, consulting UK diplomatic posts or the UK Trade and Investment Advice, consulting business representatives there or local or regional people on the ground who can give you proper advice as to those risks. Now, the question then is, but what if there is no risk? If there is very little risk of being committed on your behalf, then if I don't have a procedure at all on bribery, is that automatically going to mean that I won't have a defence? And the guidance expressly says no. There's no need for extensive written documentation. There's even no need for there to be documentation. Oral warnings to your staff to not bribe people may be enough. Obviously, though, as a lawyer, perhaps speaking with a lawyer's perspective, not having a written procedure or policy might not quite be best practice, because if you, for example, are charged with this offence and all you're going to tell me is, well, I told so-and-so on X day 6 years ago not to bribe, that might not quite get you very far. So it might be said that even though the guidance says you don't need extensive procedure and policy, best practice is still to actually put it in. And of course, in larger organisations, that's obviously something that that management need to consider. One of the things that I thought was quite interesting when looking at the proportionality and the top level commitment for the first two principles was how different is this actually really from the commercial setting that we perhaps find ourselves more usually attuned to. And I thought it wasn't actually quite different. I compared this to an insurance case, which I did last year, where it was about insuring the fire risk in a bread factory. And the real case was whether or not the organisation could benefit from a non-invalidation clause, and whether the organisation had disseminated its fire risk policy and taken all reasonable steps to disseminate that policy. Now, I was acting for the insurers, and we said, well, you're a pretty large organisation. You've got 7 factories across the country, and all you've done is you've sent an email to your operations manager at the factory with a document attached saying fire risk policy. And we said, well, clearly this obviously isn't enough. This isn't reasonable steps. And I think that's sort of the same perspective, actually, and the same sort of reasoning that one would have when assessing the bribery risks for your own company, which is if you've got, say, a third party, an insurer looking at this, are they going to go, well, hold on, you're a massive organisation, you just sent it to the top guys. None of the guys on the ground even know about this policy. If you're going to have those sort of issues, then obviously that is one where the defence probably isn't going to help you. A final point that I thought was interesting in the guidance is that although parties in the contract are free to agree, whatever terms are appropriate, it does specifically say that you don't, even if, for example, you've signed up to an anti-bribery procedure from your business partner and you don't follow your partner's business, your business partner's anti-bribery policy, that doesn't necessarily invalidate your reliance on the defence itself. So at the end of the day, what the guidance really says is that it depends on you, it depends on your business, it is fact dependent, but you have to show that you took proportionate steps to assess your policy and to implement that policy. So proportionality is probably the most important one, but the second top-level commitment goes back to, for example, the fire insurance example that I just gave. If you're running a business, you need to show that you've been active in making sure that your staff, the middle management, the key people you do business with, understand that you don't tolerate bribery, and you may want to get senior management needs to get personally involved in making sure anti-bribery is in place. There's also risk assessment, which again goes back to proportionality, but also due diligence on the people you are actually doing business with. Because you need to know, for example, if you are a commodities trader and you're operating in a very oil-rich but slightly chaotic country, then you need to know that who you are connecting with in terms of making sure your business, for example, if you're buying a mine, you need to know who you're buying the mine from. So due diligence on the persons who will perform services for you or on your behalf, so someone who is supplying you. The level of due diligence, again, depends on the risk. If you are satisfied that your agent is genuine and that you can trust them, then that's fine. But you might want to make inquiries with the business chamber, business contacts with other associations. If it's a higher risk, you may want to go and ask them for a CV, a financial account of the agent in question. Ultimately, the aim is about satisfying yourself that the person representing you can be trusted not to bribe on your behalf. What I thought was also quite sad for the lawyers in the room was that the guidance makes it clear that when you are doing due diligence, there is no duty per se to engage lawyers or consultants to assess the risks and procedures that you've adopted or the due diligence you take. Well, and it doesn't require external verification. Again, there is what the guidance says, and then there's also what is best practice. And in this case, it does seem that if you have a third party, an independent party, to look at the due diligence you are undertaking, that probably is a more helpful defense for when someone asks you, what have you done? Finally, communication and monitoring and review. I think those two principles really are quite self-explanatory, but monitoring and review also goes to reviewing, for example, the new developments in the market, especially in current changes with crypto, with AI. You might want to look at how the anti-bribery policy needs to be modified to take into account of the risks of moving money through crypto. Or for example, with AI, we've all heard about how AI has been doing fraudulent expenses lately. That might be another thing that an organization needs to keep on top of. So those are the 6 principles, and ultimately it is fact dependent. I'm going to move on now and hand it back to Lucy on the other offences.
Thanks, Anson. I think the key words certainly for me that came through from that are the proactivity. I think that's really embedded at the center of this defence. What that proactivity might look like, whether that is going to look like outsourcing of certain activities, whether that is going to involve, I suppose, a certain approach to independence. How does one independently go about assessing one's supply chain or the individuals with whom one realistically does do business? And I think there's an obvious kind of potential for a satellite industry around that, related to but different from the corporate due diligence that has always gone on into whether or not this looks like a good idea. Contractually, what protections do we have in place within our contractual supply chain anyway? So it's very interesting. I'm just going to move on to talk about the failure to prevent principle, because it's not defined by the Act, but it is distinctly different, of course, from vicarious liability and strict criminal liability. So, I mean, standing back before 2010, corporate liability would be based on the principle, the identification principle, as explored in the Meridian Global Funds Management and Securities Commission case in the Privy Council, and before that in Tesco and Natris. The identification doctrine. So only those acts and mental state of a corporate's directing mind and will can be attributed to the corporate itself. So at that level, and this is obviously before the failure to prevent any of those offences came into statute, the quest at that point was for the human agents who really form the ego or the centre of a corporation. And that was kind of loosened up a little bit in some respects by the Privy Council in Meridian, who were looking at special rules for attribution for criminal statutes with mens rea, and took maybe a more kind of purpose-driven approach, but still required that identification of the directing mind and will. And the problems that are faced by prosecutors in this context are, of course, kind of well explored in the SFO and Barclays, and the failed prosecution for corporate dishonesty in that case, because there were findings there that dishonest conduct could not be attributed to the companies. Now, this was back in 2008, capital raising exercises undertaken by Barclays, and in particular a 4.4 billion investment from Qatari entities. The allegation was that the financial arrangements between Barclays and Qatar in fact differed significantly from those that were publicly announced and warranted, and that there were secret payments made by means of two so-called advisory service agreements. The offences and the alleged offences were conspiracy to commit fraud by false representation and providing unlawful financial assistance. But the SFO found itself unable to demonstrate that the Barclays directors involved and alleged to have been dishonest represented the directing mind and will of the company for the particular offences charged. And that prosecution ended in a successful preliminary application for dismissal. The potential dishonesty on the part of the fraudulent individuals couldn't be said the judge, to extend to the Barclays Board of Directors, and that was the end of that. So that, relatively recently really underscored the fact that the agents in question must be the directing mind and will of the company, either for all purposes or for a particular function. And that only has to be stated to see how at odds that is with modern corporates and their organisational structure, which realistically is not going to involve the board of directors being necessarily involved in even extremely important corporate acts. And so we'll kind of return to this in the context of the Economic Crime and Corporate Transparency Act 2023. But one sees how different these specific statutory offences are from an attempt to identify directing mind and will. This is quite different. Failure to prevent is a completely different sort of animal. These are specific statutory offences that only the company can commit. And you are looking, as Anson has very helpfully explored, at what the company has then done when one gets to the defence to prevent those crimes from being committed. But I think in that context, it doesn't really give you the answer to what failure to prevent means. And as I say, it's not defined in any way by the Act. And it is something I think still being very much explored. But what about blind eye knowledge in that context and a conscious decision not to inquire into a fact? I mean, I would have thought that it would be really highly problematic for a company in the failure to prevent context. And that comes back, as we were just saying, to what these statutes are really about, which seems to be about promoting a very sort of highly conscious and proactive attitude to compliance and to risk management, as distinct from commercial risk management. Anson, do you want to take us forward to the next bit?
Yes.
Tax evasion.
Tax evasion. So as you can see from the slides, there were 2 corporate criminal offences which were introduced in 2017 under the Criminal Finances Act 2017. So facilitation of UK tax evasion, facilitation of foreign tax evasion. And again, you have the same defence of reasonable prevention procedures. And again, how you assess that is by reference to the 6 guiding principles that I set out previously. Now, you can see here it's tax evasion, bold, underlined, not avoidance. Unfortunately, I am one of those people who gets both those mixed up all the time. So just to be clear for everyone.
Not in her own affairs.
Not in my own affairs, hopefully. But tax evasion is the illegal one, where you don't pay or underpay your tax through deliberate deception. Tax avoidance is legal tax planning using legitimate means. So these offences clearly are designed to emulate the failure to prevent model in the Bribery Act 2010. What is particularly interesting about this, even though it was introduced over a decade ago, is that there's finally been the first first prosecution reported in August 2025 of a Stockport-based accountancy firm that was charged in connection with an alleged R&D credit repayment fraud. And 6 individuals, including one of the firm's former directors, have been charged with offences. And they've all appeared in Manchester Crown Court on 7th of August. They didn't enter pleas. There's a provisional trial date's been set to start in September 2027. Now, there is a question, of course, these 2 offences were introduced over a decade ago. Why has it taken so long for the first prosecution to actually come through? And that really goes back to the regulatory environment and why these offences came about in the first place. Because these 2 offences were really introduced in response to the leak of the Panama Papers in 2016. And David Cameron at the time said, well, on the current legislation, it's actually really difficult to prosecute a company that assists with tax evasion, and we're going to change that. So the law got changed, but then the law didn't actually get used. And in 2024, there was a huge outrage when an investigation by the Bureau of Investigative Journalism and the Observer revealed that despite over about 100 cases being reviewed since 2017, no prosecutions at all have been brought. And in December 2024, HMRC had 11 investigations and 28 other opportunities to under review. But as of yet, there had been no other enforcement outcomes and no charge had actually reached the courts. And so there was a huge outrage from Parliament. There was the MP Margaret Hodge, who is now the UK government's anti-corruption champion, said the law was a paper tiger, it was appalling, and obviously a deterrent only works if you're actually going to use it right. So that perhaps prompted a change in attitude, because that was a relatively recent development. The second point is that, giving credit to the prosecutors, it is evidentially quite complex to prove criminal tax evasion and facilitation and addressing the corporate failure to prevent that. The third is a problem that I think afflicts most public services, which is a question of funding and resource. It's not like the government is actually flush with money. So companies and professional services firms who are very well resourced can be expected to defend the charges quite robustly, so it makes prosecutions quite lengthy and costly. That perhaps goes to why it was this relatively small Stockport accountancy firm that was targeted for the first prosecution, because they potentially went for the easy kill first. And I know I just said that in the UK there's probably less risk of bribery, but maybe I'm wrong given the Stockport accountancy firm. So I think one of the other points is that the HMRC has been historically focused on recovering revenue via civil routes, and so it may be an experience issue as well in terms of pursuing criminal enforcement. But by and large, because of the change in attitude in terms of having the outrage happen in 2024, and now there being a change in the regulatory attitude. So, for example, the SFO director has recently said he wants to go hunting for cases now. And because of that change in attitude, there's been a real push as a result to get these economic crime, the criminal angle out, and to actually use the law, instead of letting it sit as a paper tiger, to actually use it and enforce it as a deterrent. And so what that really means for companies, and of course the people who are advising them, is to actually make sure that the procedures and the defense is still available to those companies, making sure you've assessed it against the 6 guiding principles, making sure that they are up to date, the paperwork is up to date, the policies and the dissemination of those policies are up to date. So much for the guidance and this comment. Moving on to the next slide.
Back to me. The Economic Crime and Corporate Transparency Act 2023. Now, we've ordered it in this way because we now jump to a kind of different concept through section 196 of the Act and statutory attribution. So the 2 provisions to be aware of in this context are section 196, as I say, and schedule 12. And these came into force on the 27th of December 2023. And we were talking earlier about the identification doctrine, directing mind and will, and the kind of corporate ego in that context. This act has widened the concept of attribution in the corporate context. So leave behind momentarily the failure to prevent world. We're back in attribution. And the law now is that if a senior manager, as defined by the Act, commits a listed economic offence while acting within their actual or parent authority, the organisation can also be guilty of the offence. So this is a sort of more function-driven, perhaps more realistic approach to attribution, given the scale and kind of complexity of corporate arrangements now. A more devolved, more distributed concept of corporate guilt and responsibility that doesn't just turn on this narrow concept of the directing mind. And this has really arisen, as I understand it, partly from enforcement agencies' kind of bitter criticisms of identification doctrine as simply being too restrictive, simply being too difficult to show that the acts can be attributed to the directing mind and will. So now a company can commit an economic crime offence where the relevant conduct is that of a senior manager. And that definition is carried into the statute at section 1964. And it's borrowed from the definition that is used in the context of corporate manslaughter offences. And a senior manager for these purposes is a person who plays a significant role in the making of decisions about how the whole or a substantial part of the activities of the company are to be managed or organised, or the actual managing or organising of the whole or a substantial part of those activities. The expanded identification doctrine applies to the offences listed in Schedule 12 of the Act, economic crimes only. So the same fraud offences that are relevant to failure to prevent fraud, as well as others. So contraventions of FUSMA, money laundering, terrorist financing, bribery, and contraventions of the Financial Services Act. So if one goes down the 196 route, the senior manager route, then there is no compliance defence. So the failure to prevent families sort of feature the statutory defence that Anson has been talking about, but Section 196 offers nothing. You will be exposed regardless of Rolls-Royce levels of compliance if a senior manager with the right authority level commits one of these offences. So these are entirely separate, but might obviously work in parallel. The Crime and Policing Bill 2025 proposes the extension of statutory attribution to all criminal offences. So that is sort of in play. And at the same time, one has the new corporate offence of failure to prevent fraud, which came into force on the 1st of September this year, and which Anson is going to talk about.
Yes, thank you. So, the CPS and the SFO have released joint guidance on the common approach to the prosecution of corporate offending. And this harkens back to what I said earlier about this changing enforcement attitude of wanting to go hunting for cases and wanting to be on the front foot. And the stated aim is basically to ensure the full range of criminality can be captured and that the prosecutions actually have a deterrent effect and to protect the public and lead to increased confidence in the criminal justice system. The guidance is quite long, but I thought that a few points were particularly interesting. The first is that it highlights the lower attribution threshold, which Lucy has just taken us through, and making it easier to hold companies criminally liable, because prosecutors no longer need to prove involvement by reference to that narrow concept of the directing mind, and they now have these other statutory routes. And the guidance draws out not just the common law routes, but also the statutory routes, and makes it really clear that the statutory routes are the ones that are preferable because it's easier to prove, it's easier to get a criminal conviction, and they're clearer legal tests. And so what you have here is that the common law perhaps is being pushed to one side, specifically because of these very strict liability offences under the statutory regime. The second point is that it's all very, and we come across this in civil fraud contexts so many times, which is it's that all very well and good to be able to prove the fraud, to be able to get a judgment, but what happens if you need to enforce? And now prosecutors are being asked to consider the insolvency of the solvency of the company earlier, and encouraged to take asset restraint powers and to use those powers before even a charge is brought. And it's pretty much sort of the concept of freezing injunctions in the criminal context. And the guidance emphasizes that corporates are expected to be able to provide 3 years of financial accounts for this purpose. And if at the end of the day you didn't provide these 3 years of financial accounts, the court may draw adverse inferences where the records cannot be produced, and as a result impose potentially unlimited fines. And so that's probably a good thing, because ultimately it's all very well and good to say, I've prosecuted successfully, these people have been convicted. Oh wait, all this money, I still haven't got it. The third thing is that entities which are incorporated by statute now feature in this guidance. Now, what does that mean? It means that statutory bodies like the NHS must now maintain adequate compliance and be prepared to cooperate fully with investigations. And this probably is right, because when you think about all the money, for example, that's been spent on HS2, we've got the Michelle Moan case. Again, these are things that go back to the changing regulatory environment and the enforcement in terms of making sure that everybody that the UK government touches is actually coming through and having these offences enforced against them as a deterrent. And finally, the prosecutors will also consider other factors as to when to bring charges: compliance failings, prior warnings, board-level knowledge, or willful blindness. In contrast, there are also genuine mitigation factors. For example, I think Lucy's just mentioned about deferred prosecution agreements. Though if, for example, a party comes and self-reports and cooperates fully with the investigation, the guidance does also make it clear that this is a mitigating factor and that deferred prosecution agreements will be considered more fully. So all in all, what this change in guidance seems to tell us is that agencies are now on the front foot, they're going hunting, and they've set out quite helpful guidance for both companies and for prosecutors as to how they're actually going to bring these cases against the corporates themselves. Moving on to the next slide and just introducing this new offence, the failure to prevent fraud. This was introduced in the Economic Crime and Corporate Transparency Act in 2023, and it came into force on 1st of September 2025. As you can see, this offence, Section 199, it applies. It is also subject to the senior manager's test, and it is again subject to the defence of reasonable prevention procedures and the 6 principles that underpin that. This offence applies to only organisations that meet 2 of the 3 following criteria. It's not aimed at small and medium-sized businesses. You have to have more than 250 employees, or £36 million of turnover, or £80 million in total assets. Now, the way that this is calculated is that it includes all your subsidiaries. So you can't just say, oh, this one particular company only had like 2 million, but then the overall corporate group is £1 billion company. So this is really targeted at the large organisations themselves. Now, just handing over to Lucy, who will talk us through it.
Well, we've touched on this one already, and so you could clearly have circumstances in which a company is exposed to both. So they have an employee who's a senior manager who has committed fraud by diverting funds out of a company scheme and into the pockets of somebody else. The company may be corporately liable for the fraud under Section 196, and the company may also be liable for the failure to prevent fraud offence under Section 199. So prosecutors will have multiple ways of getting to what they want. On the failure to prevent offence, they may of course have a defence, depending on whether or not they have reasonable prevention procedures, whatever they may look like. But thinking about it also from an advisory perspective, if you have directors who have sought advice, it is going to be increasingly important to be clear as to what they are being advised about. Are they being advised in a risk management context in respect of certain contracts, and from a legal perspective, from a civil perspective, or from a criminal perspective, or both? And if you are advising in the civil context, you need to be awfully sure that you have made that clear and that you are not slipping into discussion of liabilities that may now be sort of parallel criminal and civil in a new way. And I think that kind of brings one to consideration of the due diligence industry and whether or not that is going to change, whether or not the due diligence industry is going to diversify and expand. It's already, of course, it's there. It's there for companies who want to investigate potential business partners here or abroad. But how is that due diligence industry going to respond to these changes in the law? What is that going to look like? Is it going to look more like the sort of US model where that sensitivity has been there because of the FCPA, or is it going to look different? If we can go on to the next slide. Thank you. Schedule 13 of the ECCTA sets out the fraud offences for the purposes of the new offence, and they are, I put in a few there, but they are broad offences. And as I say at the bottom, the satellite industry, yes, due diligence and obtaining professional advice in this context, but also actually perhaps a new understanding at a corporate level of what these frauds can look like, of what the red flags are, of what the risk profile is, of what might raise that risk profile. A kind of more intimate knowledge of those issues at a corporate level is clearly going to be necessary. But of course, I think a lot of businesses will want to understand, all of this is easy to talk about in the abstract. Applied to a business, it can be extremely difficult to reshape the thinking around risk, particularly in a context where the stakes are simply so high. Will we now get more transparent testing of some of these concepts, including the simple concept of failure to prevent? But I think what is really clear is that these concepts won't be tested in isolation. They will involve professional advice at numerous levels. They will involve associated civil risks and exposures in addition to the criminal risks and exposures. So interesting, hopefully, for us all in that context. Now, it was suggested that we talk for 45 minutes. We've talked for a little more, but we do have 5 or 10 minutes left over for questions. I feel like people are moving around. So we'll stop, but thank you so much for your attention and for coming along. We didn't know whether anyone would come along to hear about our topic, so we're genuinely delighted to see you all. Thank you.